Hello, this is Ray Brescia on Legal AF, part of the Midas Touch Network. I teach at Albany Law School, but all of the opinions expressed here by me are my own. If you like what you hear and see, please subscribe, share, tell your friends about us. We're very excited to have a great opportunity today to speak to Joshua Aaron, who is an app developer, and he has developed an app called ICEBlock. And we're also here with his lawyers, Deirdre van Dornum and Noam Biale. They have just filed a lawsuit in federal court in the District of Columbia over the Trump administration's efforts to block Joshua's app ICEBlock. And that the efforts to prevent new users to download that app from the App Store in Apple. So Joshua, why don't you tell us a little bit about what this app does and why it was the target of the Trump administration's efforts to get it taken down?
Sure. So ICEBlock was a crowdsourced app that allowed our users to report public sightings of ICE agents, so Immigration and Customs Enforcement, when they were seen in public. So somebody sees an ICE raid taking place, they can tap on the map and submit that sighting. It then sends a notification out to all other ICEBlock users within a 5-mile radius of that sighting. And then people can decide how they wish to proceed. Do they want to, be involved in that area? Do they want to, walk by it? Or do they want to maybe turn left, turn around, go home, keep themselves and their families safe and avoid that confrontation? So it grew to popularity. It was launched, in April of this year, and then grew to popularity after CNN did an interview with me in June. We became the #1 app on the App Store. So we beat out Facebook, we beat out X, Discord, and it was growing by leaps and bounds. And in fact, when Apple removed it on October 2nd, we had over 1.14 million users across the country, and we were growing between 15 to 20,000 new users per day.
What is your understanding, Joshua, of why Apple took the app down?
Well, my understanding is that Attorney General Pam Bondi demanded that Apple take down the app because it went against this administration's directives. And they do not like anybody who goes against what they want to do. Their goal is to have a paramilitary force in this country with ICE. They funded them to the tune of $170 billion, making them the largest law enforcement agency, even larger than some military agencies. And they want them to act with impunity. That's why they allow them to wear face masks. That's why they allow them to kidnap people off the street without identifying them. And when we allow people to make their decisions to keep themselves safe, to not engage, to not, be where they are, they don't like that. And so from Caroline Leavitt in the White House press briefing to Pam Bondi talking to Sean Hannity and threatening me, saying I better watch out and what I'm doing is illegal, to Tom Homan saying similar things, to Todd Lyons issuing statements, Kristi Noam standing next to Trump and talking about it and how terrible I am and this app is. This is their rhetoric. It's fear-mongering to energize their base. None of it holds any water. This is protected speech by the First Amendment, and this has been litigated numerous times over the years, that when you see something in public, you are allowed to tell others about it. And that's all that ICEBlock did.
So we'll get into your complaint in a moment. When I hear you describe it, and I understand it's described similarly in your complaint, in your lawyer's complaint, it sounds a lot to me when I'm driving down the road using Waze, and I'm alerted by Waze that there's a police vehicle ahead in a potential speed trap. Is this much different from that?
It's a great question because no, the answer is it's literally identical to that. And Waze was the first one to do it, and we heard the exact same rhetoric from local, state, and federal officials when Waze started reporting speed traps. If you know where a police officer is, somehow they're going to be in danger. Well, everybody with their own two eyes can see them, and only users within a certain vicinity are getting notified about it. So again, that was litigated, I believe, numerous times. My attorneys can speak to that more in depth. But it's been ruled protected speech by the First Amendment. And, we talk about Waze, and certainly everybody knows Waze, but seeing as how this was an Apple iOS app for the iPhone, I love to point out that Apple's own Maps software does exactly the same thing as well. So anybody who's got an iPhone and uses CarPlay, they're going to see the exact same speed trap notifications. And the interesting thing about that is that when the Apple removed the app, they issued a statement saying, we're making the App Store safer by removing ICEBlock. Well, how are they making it safer when their own software is not only, installed, but you don't even have to download it. It's literally installed by default on every single device, whether it's an iPhone, a watch, a Mac, everything that they sell, they're doing exactly the same thing.
So let's turn to your lawyers. Deirdre and Noam, we know each other from other work together, but I have no involvement in this case. Tell me about the lawsuit that you filed on Joshua's behalf. Maybe start with Deirdre.
Sure. So this morning, as you said, Ray, in the district court for the District of Columbia, a court that's chosen because obviously that's where the defendants, Pam Bondi, Christy Home, Todd Lyons, and Tom Homan, act in their official capacity. It alleges that Joshua and the app's First Amendment rights were violated by these actions by Trump administration officials, coercing, pressuring, threatening Apple to get it to take down this app. As you know, software applications are protected speech. And as Joshua mentioned, there's a long series of First Amendment cases, including from the Supreme Court, ruling that speech that interrupts, challenges, opposes, warns of police actions is squarely protected by the First Amendment. In City of Houston against Hill, which is a 1987 case, the court not only said it's protected, but that the freedom of individuals to oppose or challenge police action is how we distinguish a free nation from a police state. So exactly as Joshua says, it's not just that there's many apps that do this, but the act of the administration in censoring it takes us one step closer to a police state, just like the recent efforts by the administration to silence journalists who are publishing about actions by the U.S. military, even when those actions are public, non-classified. It's in that same line of actions that we all have to speak out against.
And Noam, my understanding of the First Amendment is that it applies only to government action. So what is the relationship between the actions that Apple took and government action? And how is that reachable, if you would, by the First Amendment?
Yeah, so there's a series of cases from the Supreme Court and from courts of appeals called jawboning cases. And these go back to a 1963 case called Bantam Books versus Sullivan. And that case was recently reaffirmed in a unanimous decision from the court from 2024 called National Rifle Association versus Vulo. And essentially what those cases stand for is the proposition that the government cannot suppress free speech, cannot do indirectly through a private actor what it's prohibited by the First Amendment from doing directly. So in both of those cases, the government put pressure on private actors to silence speech that the government disagreed with. And so even though the specific action was taken by a private actor in Bantam Books, it was book publishers, and in NRA versus Vulo, it was the New York Department of Financial Services. In those cases, the Supreme Court said, well, the government has the right to, it has its own free speech rights to say its opinion and say that, they disagree with what ICEBlock is doing and they don't like ICEBlock, but what they don't have the power to do is use the coercive pressure of the government to get Apple to take action on the government's behalf. And that's what we've alleged in the first claim for relief in our lawsuit. We also allege a direct claim for relief against the government, against the government officials that Joshua mentioned, Attorney General Bondi, Homeland Secretary Kristi Noam, ICE Acting Director Todd Lyons, and the White House border czar Tom Homan, all of whom either threatened or encouraged investigation and prosecution of Joshua and ICEBlock. And those are obviously direct actions taken by the government that attempt to chill Joshua and ICEBlock's First Amendment rights. And of course, because the government was not able to achieve silencing Joshua through those threats, they went to Apple and did indirectly what they couldn't do directly. So those are the two claims that we are asserting.
And let me turn, thanks, Noam. So let me turn back to you, Joshua. We notoriously, the App Store is, it's a closed universe. You can't just post something on there if you want people to be able to download it. So I assume that ICEBlock went through vetting by Apple before it was available in the App Store. Is that an accurate assumption?
It's not only accurate, but believe it or not, when I first submitted the app, it was denied. And I thought rightfully so, because they wanted to make sure that not only was it legal, but they also wanted to make sure that when I said it was 100% anonymous, it really was, and that I was doing everything that I said I was doing. So for almost 5 weeks, we went back and forth with Apple. And I'm talking about both multiple people in their legal department, and once they signed off on it, senior officials at App Review. So it wasn't just like some person low level at App Review. These were senior officials at App Review that thoroughly vetted the app, and they found that it was perfectly legal and it abided by all of the developer guidelines. So to have them come back and say that there's objectionable content and it violates section 1.1.1 is absurd, because it's not like it flew under the radar, right? It was vetted for almost 5 weeks, and then it was the #1 app on the App Store for almost 2 weeks. So this was one of the biggest apps in the country. And it wasn't until apparently or allegedly Pam Bondi and or somebody from her, under her direction from the DOJ demanded that Apple take down the app that they acquiesced and did so.
And back to Deirdre and Noam, I think that this kind of jawboning is something that during the Biden administration, conservatives were very upset about, whether it was taking efforts to take down misinformation and disinformation around COVID-19. And Noam, you cited the NRA v. Vullo case, which is about an official in New York State's government who was, talking to business affiliates of the NRA, insurance companies, saying that they should, not do business with the NRA. And as you pointed out, it was a 9-zip decision written by Justice Sotomayor. How, is there any daylight do you see between those critiques from the right of jawboning, the unanimous decision in NRA v. Vullo going back 60 years to Bantam books, as you referenced, and principles that have been affirmed over the last 60 years? Is there any daylight in your mind between what's happening here and what's happened to ICEBlock and very robust line of cases, again culminating in a unanimous opinion from just last year, where the government might have some legal legs to stand on here?
So, as I mentioned before, the government does have the right to speak its own mind, right, and its own positions. And so, without commenting on which side of the line particular cases fall under, this is not a partisan issue. This is something that Supreme Court, a unanimous court just last year, and the New York Times, the Bantam Books versus Sullivan case is an 8-1 decision. The First Amendment issues here are not partisan. They're not specific to a policy position. They are really about the rights of the people to criticize the government and to take position on, what are the major issues of the day. And we talk in our complaint about how that's part of this country's history and a big part of why the First Amendment was included in the Bill of Rights, and how debates about immigration have shaped this country's character since its founding. And so we don't see any daylight between what ICEBlock did, which is clearly protected speech, the way in which the government coerced Apple into violating the First Amendment rights of Joshua and the app. We think that's squarely in line with the precedents from the Supreme Court.
So Joshua, and I'm going to turn back to you. Can you, on a personal level, can you talk about, why you wanted to do this and why you wanted to put yourself out there in this way? And then has this brought any risks to you?
Sure. So I'll just take them in order. I watched Trump's first administration with great disappointment as to where the shape of this country was going. And then I watched very closely during his campaign for his second term, where the hate rhetoric was amped up 100 times worse. And on the night that he was elected, I just started thinking of what can I possibly do? I mean, I read Project 2025, I listened to everything that was going on, and I could sort of see the forest through the trees on a number of different issues. But this one really felt like I could make a big difference, and the idea of the app to do so, I don't know. I mean, I honestly didn't know if anybody was going to use it. I hoped they were, but it seemed to me like it could make the biggest impact. And so that's why I developed the app. As far as risk to me, yes, my wife and I very much talked about the risks, because anytime you push back against an authoritarian regime, you're going to have major risks. And certainly being threatened by top officials in the federal government comes at great risk, because their minions love to, they love to go out on the social media platforms or send emails or even make phone calls to try and threaten, harass. I mean, I've gotten death threats. My wife has gotten death threats. I was doxxed on X. My wife was doxxed on X. Pictures of our home were out there. My private phone numbers, email addresses, home address, all of that kind of stuff was disclosed. And yes, I mean, I got a ton of blowback from the right on what I was doing. Did that stop me? Absolutely not. I'm on the right side of history here. And, 20, 30, 40 years down the road, people are going to look back and they're going to wonder why MAGA was so close to what we saw in Nazi Germany so many years ago.
And what do you say to critics who might say that your app puts government officials at risk as well?
Well, I think we sort of touched on that earlier when we talked about Waze and the speed traps and the local, state, and federal officials' rhetoric, from that angle, because that is always what they do. That's the playbook. They're going to fearmonger to the general and potentially uninformed public that if you somehow know where something is happening, all of a sudden somebody's in danger. Well, we all know that's not true, because when we pass by a speed trap on the side of the road, what do? We don't jump out of our car and start attacking the police officer. we slow down and avoid the confrontation. And that is exactly the same thing that ICEBlock was designed to do. It was simply to avoid that confrontation. And in fact, in 3 different places in the app, there was specific wording that said, this app is for informational purposes only. We are not encouraging you to obstruct anybody. We're not encouraging violence. This is simply for information.
Let me sort of ask the same sort of question to Deirdre and Noam. You all work at a private law firm, Sher Tremonte, and we know that private law firms are not immune from attacks from the Trump administration. I would argue, and I have argued, that those sorts of attacks are similar to the actions that were found unconstitutional in NRA v. Volo. But you all, some law firms have, as a expression people use sometimes, have bent the knee to the Trump administration and agreed not to take action that might upset the administration, have agreed to donate hundreds of millions of dollars in pro bono services. Sher Tremonte has taken a different tack. Do you want to explain a little bit of your thinking? And this is not the first case that you've taken against the administration. Do you want to talk a little bit about what Sher Tremonte is trying to do here and elsewhere?
Deirdre, I guess why don't I start and you can jump in. So, I appreciate the question, Ray. We as lawyers think of ourselves not just as representing clients, although that's something that we do vigorously, but we also defend the rule of law. We take an oath when we become lawyers to defend the Constitution, and we have obligations to not only to our clients, but to the court, to fellow members of the bar. And all of those sort of go to the role that lawyers have in defending and preserving the rule of law and defending democracy. So, when we saw some of the attacks on other law firms that are much bigger than our firm, better resourced, but historically have been involved in very important and critical pro bono public interest fights, we knew that this was an opportunity and there was a duty for us to stand up for the principles that we think are core to the profession and the practice of law. So we've done a number of things in that regard. We have represented members of Congress and filed amicus briefs in cases challenging the Trump administration's efforts to remove the heads of federal agencies. We represented members of Congress in an amicus brief in a challenge to the birthright citizenship order that purported to rescind birthright citizenship. I personally represented two national groups of criminal defense lawyers in the litigation that some firms that stood up against the Trump administration's executive orders brought. We filed amicus briefs in those cases discussing why the Sixth Amendment to the Constitution, which protects the rights of criminal defendants, are implicated when the government attacks law firms for the clients who they have. And then more recently, this past summer, we partnered with the Knight First Amendment Institute, which is at Columbia University, which had brought a lawsuit on behalf of American Association of University Professors and the Middle East Studies Association, challenging the Trump administration's policy of arresting, detaining, and attempting to deport student demonstrators, pro-Palestinian student demonstrators. And the claim in that case was very much a Bantam Books Vulo type claim, which was that the government is attempting to chill free speech of academics and coerce people into silence through its actions with respect to a third-party group to these students. And we had a 2-week trial in the District of Massachusetts in front of Judge William Young. And last September, he issued an order finding that the government was liable, there was such a policy, and it violated the First Amendment. And so next week, actually, we're having a hearing on the remedy in that case. And so, our representation of Joshua and ICEBlock very much fits within that line of work that we think is so important and defines us as a firm, and we think really gets to the core of the role of lawyers in society.
Now, Deirdre, I understand you're relatively new to the firm, although you come with a very long resume, an impressive resume, being former federal defender. Is this the kind of case you joined the firm to be able to bring?
Yes, exactly. And that's why I chose Sher Tremonte, because I knew that unlike some of the other law firms, they weren't scared to do what I consider to be our job. And as Noam alluded, it is lawyers' job and responsibility. And I also have a feeling of, if we chicken out, how can we expect private citizens not to follow suit? That, we have the protections of our job, we have the protections of our industry, and we have our constitutional obligations. And if we don't carry those out, we really can't expect others to. So this is exactly the kind of case I came to Sher Tremonte to do. And it makes me proud to be at a place where no person is saying, "Oh, are you sure we should do that?" But quite the contrary, that we better do that. And the more scrutiny there is, the more outrage there is. It tells us that we're doing the right thing.
I'm going to turn to Joshua for the last word in a moment, but I'm going to turn to the lawyers first. Can you tell us what happens next? You filed your case in a district court in the District of Columbia. That's fancy word for saying federal court in D.C. Are you asking for a temporary restraining order or a preliminary injunction or anything like that?
We're not at this stage, Ray, and I can't comment on exactly what will happen in the future, but we are going to continue to monitor events, and we expect that there may be a reaction to this lawsuit from the very same government officials who we've sued. So we're certainly keeping all of our options open. But we expect to proceed in the normal course in a lawsuit, and we hope to obtain discovery on what the specific communications were between Attorney General Bondi or her subordinates and Apple. And then what we hope to achieve is a declaratory judgment and an injunction saying that Joshua and the app are engaged in First Amendment protected activity, that the government's actions here violated their First Amendment rights, and an injunction preventing them from doing so again. And we hope if we can achieve that, that will create the circumstances where a corporation like Apple will feel like it's safe again to put this app back on the App Store, where they had it for months. And by the way, they had it for months up there in the face of criticisms from the government and their threats to prosecute Joshua. It was only once they got outreach directly from the Justice Department that they decided to remove it. So we hope this case sends an important message, not just to the defendants in this case, but also to the public and to corporate citizens, that the First Amendment protects everyone, and they should feel safe because of the strength of our rule of law to keep apps like ICEBlock in the App Store.
That's great. That really dovetails nicely with the question I wanted to ask of Joshua. What would you say to others who might want to get involved in their community, who might want to, protect their neighbors and friends, and maybe do something a little different, not necessarily, obviously not the same thing you did, but what would you say to people who might be afraid of taking action to advance civil rights, human rights, and immigrants' rights?
I say if you see something wrong, you need to do something about it, and you need to have the courage of your convictions. It's not enough to be an armchair warrior on social media and post something and think you're doing something amazing. You actually have to follow through, because if we all remain apathetic, they win. And so, I also want to say this. Two things. One, for all of your viewers, listeners out there that have ICEBlock installed, please know that it still works and you can continue to use it. It is just as safe as it ever was. It is just not available for download anymore. So if you don't have it, you can't get it, and there can't be any updates. And certainly if you delete it from your phone or erase your device and reinstall, you will never be able to get it again. But if you do have it, please continue to use it and help keep both yourselves and your communities safe. But as far as this lawsuit, I'd love to close with this. If we look back in our history and we remember when Ben Franklin was asked, what type of government did the delegates create? His answer was a republic if you can keep it. And his point was that the survival of our democratic republic is not guaranteed. It requires constant vigilance and the active and informed participation of its citizenry. And personally, I think a lesson that we should all take away from that is that when you see your government doing something wrong, it is your duty as a citizen of this country to hold them accountable. And that is exactly what we're doing with this lawsuit.
That's a great way to end today. Thank you so much. Thank you, Joshua Aaron, creator of ICEBlock, who has taken the Trump administration to court over its efforts to jawbone the Apple App Store to not allow further downloads of the app, and his lawyers, Deirdre Van Dornum and Noam Biale from the law firm of Sher Tremonte. Once again, this is Ray Brescia on Legal AF, part of the Midas Touch Network. Thank you all for joining today, and thank you to our guests for being a part of this important conversation and for the work they are doing.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.